I'm Matt Gishard, and this is No Holds Barred. Today we're going to talk about the criminal justice system, the district attorney's role, and the defense attorney's role. I always like to say we have a very sophisticated criminal system in the United States. And I say criminal system simply because we're talking about crimes and the prosecution of those crimes, or perhaps going back even to the arrest for those crimes. And we have a complicated system that involves criminal defense lawyers defending people, and oftentimes people don't really understand. Well, they often say, well, how can you defend that guilty person? I remember talking to a judge one time at the end of a trial, and he had been a criminal defense lawyer. And he said, Matt, I just want to tell you, my job as a criminal defense lawyer is to make you as the prosecutor prove your case beyond a reasonable doubt. My job is to make sure that you do it correctly. So I'm going to object every time I believe you did something that shouldn't come in. That's not disparaging you, but something may be hearsay, or it may be inadmissible under some others. So I'm going to make you do your job. And at the end of the day, if you've done your job properly, and I've done my job properly, the jury returns with a verdict. Unfortunately, in most cases, as he said to me, the verdict was guilty. But I was satisfied that I did my job and protected you. Let's go back and say, what is the role of a district attorney? In many cases, in some states, they call it a government attorney. In California, a case is brought on behalf of the people of the state of California. That's an interesting thing because people would often say to me, I know I'm a victim of domestic violence multiple times, but I want to drop the case now. I don't want to go forward. And I would often tell them that, well, the fact of the matter, it's not your choice. It's the people of the state of California who have brought this case. The reason why I bring that up is oftentimes somebody, a victim of domestic violence, they're fearful after they've been in the system for a little bit and it's coming up to jury, oh boy, I'm worried that I'm going to suffer injury, or this person is my meal ticket, it's my husband, I don't want this to happen. For lots of reasons, you can see why people get cold feet. I don't want to testify. And I would often say, I'm not going to be the one to dismiss the case, because now at this late date, where I know you suffered this. Now, if you want to make an argument in front of the judge and the judge wants to dismiss it, that's on him, that's not on me, because I'm not going to find you in a ditch a couple of months from now because I dismissed the case and that same person that abused you. So that's a little bit of how things work. The prosecutor is the people of the state of California, and their role is to take cases which the police have investigated, review those cases, come to a charging decision as to whether or not they believe they can prove beyond a reasonable doubt that a crime occurred and that that person that they're charging committed that crime. An overlay of that is it's the district attorney's job to do justice. What that means is the district attorney has discretion to file a case or not to file a case. And we've seen oftentimes wide discretion. Sometimes people are totally perplexed. Why didn't they charge that case? I think they should have charged that case. And well, the district attorney has broad discretion to determine a number of things. Was there self-defense in a shooting case? Was this a fight among people that the two were combatants? One of them got the worst of it. So wide discretion as a prosecutor to look at different cases and make determinations. Lately we've heard about whether it's a progressive prosecutor or not, or a traditional prosecutor and all those kinds of things. That doesn't matter. It's the role of the DA that we're talking about here, that looking at cases and deciding whether to file. Now, some people say that, well, that we're prosecuting too many people for certain crimes and we're going to slow that down. Well, there are groups that are, there are programs for mental health diversion, for drug diversion. So there are lots and lots of ways that the district attorney can move things into other arenas to help to solve that problem, a drug problem, a mental health problem, or various things. So lots of discretion on the part of a DA's office. Let's move over to the other side and let's say criminal defense lawyers. We've all heard of public defenders' offices, and some of the very best criminal defense lawyers I know are public defenders. They're in court all the time. They represent lots and lots of people. They have lots and lots of experience. What is their role? It's what I said before, what that judge told me. Their role is to represent people who can't afford to represent themselves in criminal cases, and their role is to make the prosecution prove its case beyond a reasonable doubt. Or actually, they also develop evidence independent of the district attorney, and sometimes they provide that evidence to the district attorney to show, look, we interviewed these various other witnesses that your people didn't, that the police didn't, and it shows that actually the person did not commit that crime. Or the crime has been charged in such a fashion, but it's a lesser crime. You've charged the person with a burglary, and it turns out they're not the ones who went into the store and took the property. They did possess the stolen property afterwards, so tell you what, we'll take a plea to the possession of stolen property, but not the burglary. So these kinds of things go on. I know people often get upset about the idea of plea bargaining, and frankly, the system wouldn't work if we didn't have plea bargaining, because there are many, many cases that don't go to trial. The two sides get together and hopefully kind of work things out in many cases with the help of a judge. People say, look, if he pleads to that, the judge says, I'm not going to give him any time. I'm going to actually recommend that he go into a drug diversion program or mental health diversion program, or go into a detox program for a period of time, all those kinds of things. And what ultimately is that? Back to that word that that I mentioned before, to do justice. Justice for society. That's the criminal justice system is very interesting, made up of human beings. We just heard not too long ago about a fight in a parking lot. I think it was at a Costco or something like that. And a couple of people got into it. One person got the worst of it. And the district attorney in that situation, in that county, determined that they weren't going to file. And why? Because it appeared there was some video. And that video indicated that this was more of a kind of a mutual combat. Either side could have walked away, didn't. The two of them were fighting. And we see that mutual combat a lot. A couple people at a bar, one guy's got a snoot full and he thinks he's tougher than the other, and he takes a swing at somebody. Guess what? The other guy swings back, and the guy who first swung gets the worst of it. So the police arrive. They've got two people with bloody noses. They probably arrest them both for 415, a disturbing the peace or a fight. And ultimately the DA looks at that and says, what is justice in this case? Can I prove beyond a reasonable doubt that one person started it and the other person just defended themselves? What can I prove? And in most of those kinds of cases, the district attorney, using its discretion, charges nobody. The two knuckleheads, got handcuffs on them and hauled off to jail, ultimately got out. The DA didn't file the case. That's how it works. There are statutes of limitations in criminal cases which last for, in some cases, a lifetime. Some murder cases, there's no statute of limitations. So we hear that of 30 years later, some DNA database comes up with that person committed the crime and we can prove it, and they're charged for a murder that happened 30 years ago. But in general, most are for misdemeanors a year, for some others 3 years, or depending, but there are different statutes of limitations which involve whether or not a case can be brought. Why would you have a statute of limitations? How does that do justice? Well, that does justice because let's say something happened 4 or 5 years ago. The witnesses are no longer available. Somebody's saying, I'm trying to defend myself. The witnesses are no longer around. I can't really defend myself in this case because It's just my word against his, and is that a fair thing? And we as a society have decided, no, that's not a fair thing. That's why we have a statute of limitations on civil cases and on criminal cases. But for the most part, time is something that is not helpful. And when cases are brought, you need to gather your witnesses, you need to do what you have to do. I like to tell a story. I was trying a big case at one point in Superior Court, and the defense attorney came to me and said, "I trust you." And that was something that I was pleased to hear, because in many cases, defense attorneys didn't trust prosecutors and prosecutors didn't trust defense attorneys. And I'll say again, that was when we did not have reciprocal discovery. And that means as prosecutors, we had to give all the evidence we had to the defense, but the defense had no responsibility to give us what they had. And oftentimes I'd go through trial and some witness would come up, and I'd often say to the defense attorney, "Why didn't you just tell me that? I'm not interested in prosecuting an innocent person." Going back to this scenario, true story is the defense attorney came. We were in the midst of picking a jury. It was getting close to the noon hour, and he was somebody I respected and he respected me. And he said, "You know, Matt, what I want you to do is take one of your investigators," and he named that investigator whom he knew, "and send him down to this city and have him talk to this particular person." Gave the name and the address. And we said to the judge, "Your Honor, it's almost the noon hour. We're going to take our break. Hopefully we'll be back at 1:30, but we're looking into this." So my investigator went down, interviewed that person, came back to me and talked to me and said, "You need to dismiss the case." He explained why, what this witness was going to present, and it meant that I could not prove beyond a reasonable doubt that the defendant, who was already all through the process there at trial, and no sense in doing that. Did it mean the person was innocent? Not necessarily. But based on the information that I got, I couldn't prove beyond a reasonable doubt, given the witness testimony that was going to come forth, and I dismissed the case. I was a little concerned about that, because generally at the trial level, we didn't have the authority to do that, so I quickly ran up to the district attorney himself, went into his office. "Boss, I got to talk to you." And I said to him, "I just dismissed a case downstairs." And you know what he said to me? "Did you do the right thing?" And I said, "I did." And then he says, "I got no problem with it then." And I was pleased with that. And that's the idea of doing justice. What we want from both the defense side and the prosecution side is to work together, when possible, to do justice. We can all think of a whole bunch of cases where we think somebody should have been prosecuted and they weren't. There's a case in San Francisco right now. There was a shooting by a security guard in a store, and the DA made the decision not to prosecute. We don't know the facts of the case. Citizens in the city are in an uproar and think that he should have been prosecuted. I don't know the facts. Oftentimes come up as what we call a self-defense case. You may not like it, but self-defense is something where a person feels danger and from an objective standpoint uses whatever force necessary, and in some cases kills somebody. I've seen, from just anecdotally and from what I read in the newspaper about that case in another city, where the prosecution decided not to file because there is the issue of self-defense. And if you recall in a prior no holds barred, when self-defense is raised, the prosecution has to prove beyond a reasonable doubt that it's not self-defense. And again, that's the same burden that applies in proving somebody guilty. So they have to prove somebody guilty, and then they have to prove beyond a reasonable doubt that it's not self-defense. Those are high burdens, and again, justice being done in a case like that. Now, does the family of that person think it's justice? No, but that's what our law is, and we have a very sophisticated system of laws on the criminal side. Some of you may disagree with, but the fact is very, very important that we apply those rules of law and we reach a just result. I will say one more case that I had some time ago. Somebody had a wallet gun. I may have mentioned this to you in a prior session. You take the gun, put it together with the wallet, and it's a crime. You can have the gun, you can have the wallet, those aren't crimes. Well, I went to trial. I convicted the person of possession of a wallet gun. The jury was very unhappy about it, but they found him guilty. And they asked the judge afterwards, "We want to talk to you." And what did they say to the judge? "We're very unhappy with this result." But they did their jobs, and the judge, in sentencing, that's where sometimes justice applies after a guilty verdict, as the judge uses his or her discretion to decide what is an appropriate penalty, if any, under those circumstances. I hope you enjoyed this episode of No Holds Barred. Please hit the like and subscribe button. It helps us with our YouTube algorithm. And stay tuned for our next episode of No Holds Barred.